everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Got to remind everybody hit that like, share, and subscribe button. There's a PayPal link down there for anybody who wants to share some love. Every little bit is appreciated. Always helps. Been a while, so please do share some love. And of course, the panel link is down there for anybody that wants to join the panel. We've got John with us again tonight. How you doing, John?
Yeah, we're doing good, Keith. I guess
Good.
you snuck a show in last night, huh? I missed that one.
Yeah. And that's gonna bring about before we even get started. I've got some other things planned here too, guys. Like I said, I want to step this stuff up, and I'm going to be meeting with the community leaders and things like that. And hopefully, sometime this summer, I'll be able to do some naturalist to survivalist videos, things like that. And so I've got lined up several different streams that I want to do over the next few days. So be watching for them throughout the day. I might do them at like 10, 11 o'clock in the morning, late afternoon, but I'm going to stick with the 6 p.m. one, and as well as I might even start adding on some 9 o'clock ones just to kind of help fill in some of this information, not so much necessarily for you as a current comprehension, because there's going to be a lot of information coming out here, but as a matter of establishing, again, my own journal record of this information that I'm going to be bringing out in these community actions. So a lot of what we're talking about right now is what I'm dealing with currently in my situation with myself and my companion. And that's why we're talking currently about the real party in interest. We're going to be talking about individual sureties and enforcements. Let's see what else we've got. Oh, I'm going to do one on the Motor Vehicle Theft Prevention Act, special or specified conditions under which stops may be authorized. We're going to be doing something on revocable and irrevocable trusts, things like that. So pay attention. I'm going to start stepping it up. And like I said, I don't want to make them, real long streams or anything. So a lot of them are going to sit right about an hour, hour and a half, maybe 2 hours. And hopefully that'll allow me to put some information out. Again, not necessarily for you guys at this time, but it'll be there for you to do your research, which I always inherently tell everybody: don't believe me. Don't believe your neighbor. Don't believe the government. And for crying out loud, don't believe your mother. Do your research so you know. So this is just a correlation prospect for you when you get ready to do this research. Okay? So we're going to continue on where we left off. Go ahead.
So you're just expressing how we're functioning better in on the public side, but going into the private, it's like we're in
Correct.
between two worlds right now. Okay, yeah.
Right. Everybody thinks there's one path, and there's not. There are multiple paths in this commercial system, and it just depends, again, on your particular needs and definitions and how you apply them to your life. This is why, again, another reason that I say is the ultimate end effect is for yourself. So that's going to have to take the discernment for yourself to learn how to correlate it or apply it in your life. If it doesn't apply, then you need to be able to explain why. This is the inherent thing about feeding a man for a day if you give him a fish. But if you're giving him stuff that he doesn't need, then you're just encumbering him. And that's what this system does, is giving you all kinds of things that you really don't need. So it's just a matter of going through and processing out what you don't need. If you actually do want to perform the functions of public office and have a corporate capacity, you need to know how that's regulated so that you can fulfill that. Otherwise, there are errors and omissions that will come back to bite you. They're the ones that made the rules. It's not going to bite them. So, we left off last night. Indeed, at common law, the assignee was for many purposes regarded as the actual plaintiff. Okay, so it's the assignee, and this is just like the addressor and the addressee on an envelope. The one that's addressing it is the addressor. and the one that's receiving it is the addressee. So here, the assignee is the one that gets assigned, who is authorized by the one that authorized him, known as the assignor. This is the SS5, where they send you a card that says you are the authorized representative. You are the assignee, and you get to make the choice on your signatures. They just don't teach you what those choices are. Far more difficulty has arisen where the assignment is for collection only. Do you see what happens? They come to you as the assignee and profess that the assignment is for collection only. Now, wait a minute. Aren't you the one that's supposed to be giving to the beneficiary as the benefactor? Aren't you the true issuer? And on the private side, that's a private issue. And instead of making it a private placement, they make it a public offering by pooling it as a private offering with the other private offerings, and then entering it into the investment system under a different name, the court's name, the court registry investment system. And this relates to the probated estate, the Health and Human Services, known as the one that perpetuates all of this through the actions with the county registrar and the birth clerk at the hospital that create the original instrumentality.
So they try to add data to justify their version to be beneficiary.
Correct. And it's the supplemental data elements, the ones that are have a greater truth, the a fortiori, a greater truth, that beats the presumption and prevents them from persuading anybody as to anything else. Again, this goes to the perfection of the title. The persuasion can't be had if the guy that's name is on the certificate or in the certificate and gets to sign on the certificate, proving that he's not liable for the person named in the instrument, then who is? The overwhelming weight of authority is that the assignee is the real party in interest. Again, correlating with UCC 3-402, because he's the real party in interest, he's not the liable party. Again, who is the liable party, folks? The Postal Service.
Trustee,
correct. Yeah. The Postal Service. Right now, what's happening is that it's not the Postal Service that holds the title. It's the Social Security Administration that's running the management as trustee for Health and Human Services, who is supposed to have the title, but you get your title from who? Secretary of State. Secretary of State is the one that gives me that bond, which is a document of title. It's a certificate of title. So if they're the ones issuing the certificate of title, they must be the holder of the title. So now I get to give a directive. Now that I've got that bond, which is an obligation or other security of the United States, I get to give a directive with expenses incidental to transfer title to the agency. The agency would be the Health and Human Services as a matter of estate recovery from probate. In that, I give a directive, expenses incidental to transfer title to the United States, so the accounts levied at the state level can be settled and cleared with all known creditors, making all parties whole, and then any remainder from those credits established already through that record being insurance credits, unearned income credits, and anything else, such as fees, funds, fees, fines, taxes, and stuff that was paid in that was made as an error, reflect back. Now you get to, once those are all settled and cleared, that remainder is a resurrection in a merger with a new name, and that is the expenses incidental to transfer title to the Postal Service, who I believe is supposed to hold the true title, so that it can be matched up and balanced with the general ledger. That way, if there's any out of balance accounts, the Postal Service has 3 days to research and resolve the issue, because that's truly what it affects, is the general ledger. Now that account is already set up in my instance as online postal service account known as an enterprise payment account, which is a merchant account, so that any contracts have to go through that first because it's an international account and not a resident or a United States citizen any longer. It is an agreement with the United States citizenship and agrees to an armistice that is now binding because of the notice. Listen, you created a United States citizenship and then conferred it to me as a nationality, a gift, and that nationality is a United States business. I'm just renaming the business through a merger. I own the majority voting shares of anything that comes from my mouth. Like I said, keep my name and my companion's name out your mouth. You are not the investor. You are not the principal. You are not the real party in interest. I have no written consent to communicate with you about the conveyance of any debt, particularly one in my name. My yea is my yea, my nay is my nay. It goes on to say, but the arguments pro and con have been much beclouded, and some of the courts adopt. Again, this is not law, people. The courts adopt a contrary holding instead of frankly recognizing the substantive law gives such an assignee the right to sue and that the assigner's rights are purely against the assignee. The courts have sometimes attempted to decide the matter exclusively by this statute. You cannot forego the substantive law. You cannot forego the substantive law. Statute. Exclusively by this statute is voiding the trust. It's saying that the trust does not exist. It's saying that there is no express trust. It's denying the trust and that they are a trustee. Contract terms and conditions required to implement executive orders or statutes or executive orders hyphen commercial items, commercial services. Probate is a commercial service wherein the trustees, the administrators, are supposed to get paid for delegating the authorities and making the assignments necessary to distribute the estate assets to the beneficiaries. And if there be no beneficiaries found, then they still have to settle all the creditors that are known and distribute the assets as abandoned so that they go to the state for possession until in, brain fart, held in abeyance until a rightful claimant come forth and make a valid claim. Some authorities have strenuously objected to the obvious injustice, as they say, of nullifying the real party in interest statute by permitting one to sue who is not beneficially interested. Of nullifying the real party in interest statute by permitting one to sue who is not beneficially interested. See, that's them third-party debt collectors that are beneficially interested by enforcing through the clerk of court registry investment system the investment of your name, where they convert it to a firm name and attach an obligation that wasn't there to begin with. This is why we demand the documentary evidence of the underlying obligation that is already there. Good faith, under the full faith and credit of the United States, as public servants of the public trust, despite their contract. If their contract is a violation of the trust, they have a duty to let them know that, hey, my contract is violating the rights of the benefactors, the beneficiaries. I have an obligatory moral duty to state that. Otherwise, I can be charged with misprision of felony for allowing those rights to be violated while knowing they're being violated. Yet they don't do this. Why? Because they're incompetent. They don't know trust law. They're only doing their job. They don't even know contract law. The camouflage of a simulated transfer, says Mr. Kerr, cannot make the transferee the real party in interest. With all due respect to the decisions which under forced construction held otherwise. That's that forced construction of a contract or trust or both. As you walk into that court, an administrative Article 1 corporate court constructing a contract under a presumed irrevocable trust to establish a revocable trust wherein you become a transferee and transfer the property of the trust, the irrevocable trust, to the revocable trust to the irrevocable trust. It's all a shell game. 3-card Monty. With all due respect to Mr. Kerr, he is trying to decide a question of substantive law by a procedural statute. No, he's not. I disagree with that statement. It says, with all due respect to Mr. Kerr, he is trying to decide a question of substantive law by a procedural statute. No. He's trying to decide a question of substantive law, proving that procedural statute cannot subvert or evade or avoid the substantive law. The substantive law is the choice of jurisdiction of the very plaintiff. And the plaintiff is the real party in interest. I don't care if you want to name him as a defendant, because what you've done is you've named the name of an estate. And the state as a plaintiff is not an estate. They are not of like kind. The name of the state proves they are a third-party debt collector. That is all they can do, is collect debts on behalf of the United States, obligations and other securities of the United States. Otherwise, what they're doing is making private investments and converting them to public sales. Go ahead.
Yeah, I mean, substantive law, they're supposed to define and regulate the rights and duties of the parties. They're not doing that in court at all.
Correct. They're not listening to the real party in interest, because the real party in interest doesn't know that he's the real party in interest, and that's pretty much all it takes. Hey, I'm the real party in interest, the benefactor that gives to the beneficiary, known as the grantor, who is the trustor, who assigns a trustee. You're hereby assigned as trustee in this constructive trust before this court as a revocable trust, so I can transfer the proper assets to the proper beneficiary without them being diverted through your illicit process. Procedural statutes, contract terms and required. So now you're bound by contract under the surety bond held by your surety company, and that's who I make a claim against, the surety company. They're the surety. You're the bond. You're the one bonded. They hold the surety. They're the liable party. So I'm going to sue them. And when they don't like me suing them and taking them for a couple of cool $1 million, they're going to say, "Hey, buddy, you cost a cool $2.5 million, and you've only generated $150,000 as payments into our fund. We're going to have to get rid of you. You're not a good investment." Hit them where it counts. The investment. It's the surety bond companies that are making all these investments. They're investing in surety bonds and then converting them to government obligations. That's how you enforce the law. You grab that surety bond and then you transfer that document of title, again, expenses incidental, so you can enforce that surety bond just like you would enforce a birth certificate. It's already got a value to it, though. Your birth certificate, you just got to put the value to it. You got to construct a plan, a contract plan, and put a value in it and have them agree to it. Part of that plan is to pay them for their private services of enforcing the laws and making sure that they recognize you as the benefactor from this point out. And since you're a principal in that investment, all the income made from that investment, you get your first share first. You're the principal creditor. That's the investment scheme, guys. And you get to make your own private issues by capturing a public bond, which is an obligation or other security of the United States, which includes all bonds. So it doesn't matter if it was the Secretary of State that gave it to you. It's a bond. And they already have a corporate bond for that foreign trade zone, and it's listed on the Federal Register as a chartered corporation, allowed to issue public bonds on behalf of the United States. So they're converting those private investments to a public bonding. It's a conversion through subrogation where you become the surety. As a signee, imagine, who's supposedly the real party in interest. So again, remember, as the assignee, you have the ability and the responsibility as an obligation to yourself to protect yourself. And you can only do that through knowledge of how to qualify that signature. Nobody's ever taught you that.
So they're offloading the trustee work onto you, and
correct.
In return, they make investments. Problem is, we don't
Correct.
see it. We don't know about it.
Yeah, they're subrogating themselves as the investor and issuing the offerings as public sales, public offerings, by pooling everything into their in pooling everything, and then they put it in their name, which is a public name. If the substantive law gives no such rights to the transferee on such a simulated transfer, all well and good, then he should not be allowed to sue. That's the premise. See, the substantive law doesn't give any rights to a transferee of a simulated transfer, and that's what the procedural law is. It's a simulated transfer. Again, let's talk about that tax transfer stamp. Excuse me, it's actually called a capital transfer tax stamp, because what you're doing is you're transferring capital, which is known as assets, which is known as property. And if there's no damn stamp on there, taxes weren't duly paid. But cases already cited to the effect that he is the real party in interest take the position that the transfer itself, if not the real party in interest statute, did give him certain substantive rights. The right without recourse, without prejudice, not to take on a liability, and to be able to transfer the document with its underlying obligation to the Department of Treasury for reissue of a new security or redemption. Indeed, though there is little direct authority on the proposition, it seems clear that before the codes and an assignee for collection could acquire the same rights as any other assignee. Indeed, though there is little direct authority on the proposition, it seems clear that before the codes, an assignee for collection could acquire the same rights as any other assignee, barring possible objections as to champerty. What is champerty? Let's look that up. I wonder if that's chancery. I'm sure it's supposed to be chancery, which is trust law and equity. Yeah, it says that's the only way. or only place it's found. Oh, there it is. Champerty. An agreement in which a person with no previous interest in a lawsuit finances it with a view to sharing the disputed property if the suit succeeds. Sharing the disputed property if the suit succeeds. So, hold on, folks. I'll be right back. Hello.
Hey, we're here in the front.
Yeah, the door's locked, but you've got the keys, right?
Oh, yeah, I do.
Yeah, dogs are locked up. I'm doing my stream.
Oh, are the dogs away?
Dogs are locked up. I'm doing my stream.
Okay.
Oops, sorry. I thought I was muted. So anyway, let's see here. It says, an agreement in which a person with no previous interest, remember we read that? In a lawsuit, finances. What was finances? Remember what finances was? When we looked up finance on etymology, didn't it say something? Yeah, didn't it say something about settlement? So let's see. Finance, an end, settlement, retribution. You contributed to the wrong one. It needs to be retributed. An end, an ending, pardon, remission, payment, expense, settlement of a debt, to end, settle a dispute or debt, a payment in settlement, fine or tax. So let's go back and look at that again. What's that say? An agreement in which a person with no previous interest in a lawsuit finances it with a view to sharing the disputed property if the suit succeeds. So, if that disputed property is an entitlement to create money as an investment, then I agree to share it with anybody who would like to make an investment and create some money. I'm the principal. I get the lion's share. The United States wants to join in. I'd be glad to help settle any future debts. On behalf of the United States and any poor sucker out there that doesn't know how to do so himself. Leviticus 25, verse 25. If thy brother shall be waxen and poor, and sold off his belongings, and one of his kin come along to redeem him, he shall so redeem him. It's based upon knowledge. That's the true benefit. Once I have knowledge, I can now, instead of just giving him a fish, like giving him another car where he's going to turn around and lose it by selling it off, I'm going to buy it back and teach him how to not sell it off. Parable of the teaching of the fish. You don't just give a man a fish. You teach him how to fish. That's the true benefit that keeps on giving, because then he can teach somebody else. If you give a man a fish, he can't give another man a fish unless he gives up the fish that you gave him, freely giving what was given freely. But then he can only replace that fish if he knows how to fish, or has to turn around and beg from somebody else to get another fish. So inherently, the main principle, again, is the teaching. So let's go back. Acquire the same rights. If then the assignee for collection acquires substantive rights, in other words, it's something that's given to him, and they can only be given to him. How? By the consent of the one that already has substantive rights, because the only one that can really perfect the title, again, is the one who holds that name. The debt collector, known as LVNV LLC, cannot sue in that name. But if he can acquire substantive rights to sue for it, he can't name it as a defendant. But that's exactly what they do. They name it as a defendant or respondent. It is difficult to see why he is not a real party in interest. That's the only difficulty. I don't see it as a difficulty at all, because again, if the real party in interest is the estate or the assignee, the only one that can cover for the estate being in the name of Keith Little or Keith Orland Little, however you want to do it, is the one signing Keith Little. Now, the guy at LV Envy, unless he's a part of the laundromat, in case you guys haven't watched that movie, I suggest it, the laundromat, and they're just sitting behind some door in a office, signing the same name over and over again, or being told to sign the name of the applicant or whatever, and getting away with it and being paid for it, is obvious fraud. So don't sit here and tell me how to uphold my substantive rights when it comes to the name and the entitlement known as the entity, a United States business, that somebody else claims to be able to manage that business and doesn't have any substantive rights in it unless he makes a false claim, 12b-6, upon which no relief can be granted because he really didn't give anything up. He really never gave anything. In accordance with the principles already expressed, it is held that in the case of a negotiable instrument payable to the order and transferred by delivery, the transferee, whether beneficially or for collection, is the real party in interest. Negotiable instrument payable to order, without recourse, without prejudice, paid to the order of Keith Orland Little, all uppercase, by Keith Little, upper and lowercase, by Benefactor, signed Keith Little, in the interest of the estate, whether beneficially or for collection, is the real party in interest. Don't give them the ability to collect because you're the one that's given the directive. It's a direct routing. Denies any third-party interveners or intermeddlers. The same result is also arrived at by virtue of the Uniform Negotiable Instruments Law. The same result is also arrived at by virtue of the Uniform Negotiable Instruments Law. This is similar to that signature under UCC 3-401 and 402. It's a presumption that you're signing in the legal name and therefore taking on a legal capacity by not letting them know that the legal capacity is not as a trustee, but as a benefactor. Otherwise, the trustee presumption rides. It is also decided weight of authority that where a chose in action, either negotiable or non-negotiable, has been transferred for collateral security. For collateral security. So it shows there is a security interest in there. And the obligation or other security of the United States is the priority interest in the obligation. Again, that's in the interest of the United States for the account of the United States, its obligation to uphold full acquittance and discharge, and for the person making the same, so that no person shall be held liable in any court. That's like kind. That's trust words. That's trust law. The transferee is the real party in interest. Partial assignment of chose in action. As preliminary to the cases involving partial assignments of choses, care should be taken to distinguish them from the case where A assigns to B, hold chose with a proviso that B shall collect and return to A given percentage. As principal, A assigns to B the whole chose with the proviso that B shall collect and return to A his principal percentage. This is like wording with the sales agreement I got from the local emergency room that said, in simple language, I'm not going to verbatim, but it's basically about the same verbiage, that the customer agrees to make third-party payments so long as it's understood that credit is given to the customer's account. That contract is a constructive trust or constructive contract, and you can put the words in it or interpret the words in it and express the trust. Like I said, all contracts are developed under a trust. Read the trust language, find out what your position is, and enforce that as a holder in due course of that instrumentality of a government. Clearly, all those cases, B is the one to sue. So if the customer is the one paying for the services for the third party, and it's to be understood that credit is given to the customer's account, that customer's account is the estate account. So again, he has to sue in his name. Customer gives payment for third party. It's understood that credits are given to the customer. A and B become the same. Do you understand? Just like grantor and trustor are the same, and they're the same as the benefactor. You just play the different parts at different times. But it is difficult to see how, in an action either at law or in equity, the partial assignee may sue without joining his assignor. I want documentary evidence of the underlying obligation that made him an assignee, saying that he could sign anything and bring suit against the estate without bringing in his name. See, they're signing on behalf of LVNV. The court clerk is signing on behalf of the court registry investment system. And they're converting the last name to an investment firm name and claiming it's the obligor and expecting you to pay the obligation. That's why we talked about joinder. Without joining the assigner. See, again, it's the Federal Registry that assigns that the state can even have a foreign jurisdiction, foreign trade zone to create its statutes. It has a contract with the federal government for federal acquisitions. It cannot acquisition property for the state. It can only make a claim in the interest of the state. It must be for military use or the United States. And that goes for the county and the municipality as well. Nearly all of the cases hold that the assigner may sue, either alone or with the partial assignee. One may well raise the question as to why the partial assignee should be joined at all. So if the United States is the assigner of a foreign trade zone to the state, they are the assignee. And it is the extension of that foreign trade zone by a resident determination deemed necessary through the state that this is all being placated, that you are a port director and responsible for all the taxes, duties, imposts, and excises through a needful place and building under a 14th Amendment person under the 14th clause, a foreign entity, for providing commercial transactions under Article 3 that are qualified with a communication under Article 1. That's that conference of the nationality, that United States business. They're the assigner, not the state. The state's an assignee, and the presumption is that you're an assignee as well under the state, who becomes an assigner by assigning you as a co-assignee. Just like A is the same as B, assigner is the same as assignee, just a slightly different capacity at different times. This, of course, can be justified if the action is equitable in character. One may well raise the question as to why the partial assignee should be adjoined at all. This, of course, can be justified in the action if the action is equitable in character. That's why we use the common law, which is Supreme Court, which is equity, which is, again, a mistake for the trustee being the state. Again, my firm contention is that if it's a judicial determination that needs to be made by each action is a constructive trust, constructive contract, wherein the evaluation must be placed in there. That's a judicial determination for each incident. That should be done by the Federal Register, so that if it's out of balance, they have 3 days to research and resolve that issue with the General Ledger. Before the codes, the partial assignee was regularly recognized in a court of equity and was permitted recovery on bringing in the assigner and other interested parties. Now, doesn't that sound like expenses incidental to transfer of title to the United States, so that you can settle and clear all accounts by paying off all those creditors, all those people that have some kind of interest in it? Even if they are a third-party debt collector that bought the debt, see, again, the debt wasn't discharged by the supposed original creditor. It was charged off. Okay? They just got a tax relief on that. There still remains a charge that needs to be discharged. So that's what the third-party debt collector is coming after. He wants you to pay him so he can turn around and discharge it and get those credits. Before the codes, let's see. But in a court of law, no action was brought by the partial assignee, since he had no standing whatever. So you don't have standing in a court of law. You have standing in a court of equity as a mistake for being assigned as an assignee as a public service trustee. Had you understood the capacities and how they work, you'd have never taken upon that unless you could qualify everything. Come to discover, there's a lot of things that need to be qualified in order to prove that you are, in fact, a public servant of the public trust, performing the functions of public office in your official capacity to do such trade and business commercially requiring a license. Following the principle heretofore stated, that the real party in interest statute gave no one a right to sue who could not have done so before. Now that they merged common law with equity, and the common law has equitable remedies, now they can sue where they couldn't before, but it doesn't negate the fact that you have to sue in the party in the name of the real party in interest. So what they're doing is they're claiming an interest in settling a debt. They're claiming an interest in financing. Who comes forth to settle it? The benefactor comes forth as settler to settle the debts. Doesn't take a third-party intervener or intermeddler. Just, again, takes knowledge. And of course, you can pay off that third-party debt collector with it. It's an estate. It's based on credits. It's a device, a credit device used to obtain money, property, labor, or services on credit. Go ahead and pay them. Do it on credit, though.
So, Keith, the real party is someone who's like substantially interested, right? As opposed to like nominal or formal or technical interest.
Correct.
Right?
Correct. You're the only one that really has is a real party in interest, again, because every time that vessel goes out there, somebody attacks it. Guess what? That's a claim of a party in interest. And by statute, they get that claim. So that's the presumption that you have to beat, is that they're not an actual real party in interest, but they've made a claim as a real party in interest. Now here's their claim. The documentary evidence says that the original creditor made an agreement with me. Okay? That original creditor wasn't paid off. He wasn't made whole. That debt still exists. He was able to charge off the tax part of it, and get recompense for his part of that contract. And that's what it is. Nobody expressed the trust. When you express the trust and you're the benefactor, it's the trustee that pays all the expenses. Okay? And it's the trustee of the estate. Now, the state is claiming to be the trustee, and they're the holder of the record, and they're supposed to be the one paying all the bills. And why are you? See, you get all them receipts. Commanding officer shall cause the receipts to be issued, so the spoliated owner may obtain indemnity. In other words, he gets paid back for what he paid out, because there was no trustee around to make that payment at the time. So he used a credit device to extend the credits. He deserves those credits back. Third-party customer agrees to make third-party payments so long as it's understood that credits are given to the customer's account. And that's according to the customs laws, which relate to the individual sureties. And that's why I said I'm going to be going over those too. It would seem that the partial assignee would be an improper party in an action at law. At law. It would seem. And that's why if you have a choose in action, you go to equity, because now it's not at law and it's substantive law, your choice, which is equity, making it the substantive law and not the statutory law. See, if you get stuck in that statutory law, that becomes that substantive law. How does that happen? Because you never mention trust or equity. And it's not just a matter of mentioning trust or equity. You have to know how it works. You have to know that these corporate activities have nothing to do with common law. They have to do with the 14th Amendment, which is rules for government. The articles of the Bill of Rights, the first 10 amendments. That's for the people as a surety. It's an insurance underwriting, the Constitution itself, that all public officials at all levels take an oath to uphold, because they hold they are the bonds. They are the ones bonded. The surety companies hold the bonds, and those bonds are a performance bond, obligating them to perform according to the people, to the benefit of the people. Where the opposite conclusion has been reached, it is due principally to the statutes in the Reformed codes. Most code states have a provision that there shall be but one form of action. Most code states. That's our Federal Rules of Civil Procedure Rule 2 says there is one form of action, the civil action. And one at least provides that law and equity may be administered in the same action. Why? Because the civil action is a mistake. Civil is not the common law. It is the contract between men of the common law. And if there's a mistake in the contract, that opens the door to equity to resolve it without contract by holding those obligated to contract already to just correct the records, because that's the only thing that's wrong. The trustee is not the state. In my opinion, again, according to my research, everything points to the Postal Service, United States Postal Service, as a represented agent already, the trustee for all postings in all postal accounts, meaning any account where you post, even Facebook. Why? Because they are the ones that are supposed to be helping educate the people of the countries in communication, as they're supposed to be the top professionals in communication. This sometimes makes it necessary to determine whether the action is legal or equitable in character. This sometimes makes it unnecessary to determine whether the action is legal or equitable. Again, if you're not concretely bound by those statutes because there's an error, mistake, omission, whatever, then it must be reconciled first to see if it can be fulfilled. If it cannot be fulfilled, then it becomes an impossibility. That means there's obviously a mistake that cannot be remedied, and therefore your only remedy is inequity, where you get to create your remedy, which means you get to create what? Your own little revocable or irrevocable trust. A private relief law known as the Keith Orland Little FBU Trust and Estate Law. It's a foreign law. It's a foreign money judgment. My values are different. My assessments are different. I am not the same as you say. That's an assayer. That's what they use for gold critiquing. They use an assayer. They make assessments, appraising things. That's what my dad was, a real estate appraiser. He went out and made all these measurements and everything and made an assessment for the tax assessor. So he could create a value of a commercial interest, saying that there's some kind of commercial interest at that private property. See the problem? The commercial interest is in the contract postal unit, and you acting as an assignee for everything that comes in and out of every port. Again, presuming that you're a port director, giving directives without knowing what you're directing it to, because you don't know how to directly route it from benefactor to beneficiary and take benefit of the benefit. There is usually also a statute providing that persons having an interest in the subject of the action and the relief demanded may be joined. What is the subject of the action? Well, the state is known as the trustee. That's why their name is on top of that document. And the second name in the document is known as the beneficiary. The beneficiary is deemed to be the true owner. So again, they have principal interest. And they get to demand the relief. That's a demand deposit or a certificate of deposit. Again, that birth certificate can act in many ways. It just depends on how you direct it. This could well be interpreted to make the partial assignee a proper party at law. This could well be interpreted to make the partial assignee a proper party at law. So if I take one of those birth certificates and I give it to the mayor and I sign him as the proper party at law as a partial assignee, assigning him to collateralize that bond with his bond. Equal consideration, equal benefit. It's the formation of a contract as a private issue for private placement with a public official to collateralize their surety bond, so that if anything needs to come to any court suit in court, there's already equal consideration and the claim is already made and financed to the surety company. Does that make sense, John? Maybe I'm off there.
Yeah, and see, the real estate investment trust, that's like the insurance for the citizenship or for the U.S. business, right?
Yeah. That's what the surety is all about, is the U.S. business, to make sure that they take care of their obligations and other securities, which includes all bonds. Everything's a bond. A man is what? Bonded by his word. And then you go ahead and sign the document. That's the assignee. You just bonded yourself as an assignee without letting them know you're the assigner, assigning them their trustee position as the trustee, recognizing you without recourse, without prejudice, paid to the order of, as a benefactor, to the estate, Keith Thornton Little, all uppercase, by their legal representative, Keith Little, upper and lowercase, as so designated and authorized by the Social Security Administration, to give this directive and display that I am not liable for the person named in the instrument by signing on it.
Yeah. This also makes me think of the color of title. You know, this is from Barron's. Color of title is an instrument which appears to pass title, but that is not valid because the title is lacking in the person conveying, or because conveyance itself is defective, Keith.
Yes, that's why. Yeah, that's why you can only transfer title in your name. Same thing. That's why I say these courts administrating probate cases. The only reason they could probate it, not be in that name, is because the testator has already passed on, and there's abandoned property that needs to be distributed. Otherwise, it's considered waste and abuse, and somebody has to be paid to take care of it and haul it off and to dump it. So let's see if we can hold it in abeyance until a rightful claimant come forth and make that valid claim as a true inheritor. That's how this system works. In other words, barring a few minority holdings, the decisions on partial assignment of chooses in action do not in any way disprove the theory that the real party and interest statute is purely procedural in character. Does not disprove it. In other words, they're saying it's procedural in character. A question on which a variety of opinion has been rendered is that of a suit by an insurance company against a defendant for his negligence in causing the loss to the insured, where the insured has already been reimbursed by the insurer. This is called subrogation. Remember I talked about the prepaid expenses, and under that is the prepaid insurance. If you're prepaying insurance and you prepay it for a month, and then at the end of the month you didn't get in an accident, therefore didn't receive a benefit as the benefactor giving to the beneficiary through the estate, goodness gracious, shouldn't that be rollover?
Yeah.
I mean, you didn't receive a benefit, so you should get that back. Equal consideration. They never give that back. Why? Because it's considered an investment, a creation of money. Now they have money and they're claiming a debt against you in which they get the credit side. And you give them the money every month. How sick is that? So it says, as a rule, such a cause of action is not assignable. As a rule, a cause of action is not assignable, and the insurer is permitted to sue only by reason of his being subrogated to the rights of the insured against the tortfeasor. Once again, telling you that someone has committed a tortfeasor. Somebody has administrated an estate of a person who is in fact alive. Of course, in jurisdictions where an assignment is permitted and this has been made, the rulings already discussed apply. In other words, the civil presumption rides. The legal fiction is a presumption of the facts presented to the court until properly rebutted. Once you properly rebut them, they have still the duty of persuasion. So once you rebut them, they have to rebut your rebuttal by coming with a greater persuasion. How can you come with a greater persuasion than the truth? Like I said, the truth needs no defense. Just put the truth on the record. What is the truth? I'm not the trustee, I'm the benefactor. Learn how this trust law works and understand how to displace yourself out of those contracts and put yourself specifically in the trust through expression. That's an express trust. And they're trying to construct that before you every time you apply for something. Of course, in jurisdictions where an assignment is permitted, and this has been made, and we already had that. The weight of authority is that the insurer may, if he pays the total loss, sue in an action at law. So again, if I'm the one that gave everything, that is the value already given. Therefore, I've already paid the total loss. They already have access through an access device to discharge a debt by use of credits. And it's called extending the full faith and credit of the United States. Some say the insurer may sue alone. Others say he must join the insured. There is, however, some authority to the effect that the insured is still the real party in interest, and it is submitted that this is the sound rule. Sounds to me like every time you pay for something, you are the real party in interest. This is not like the case of a total assignment of a chosen action. In that case, the court of law recognizes the rights of the assignee. See, when you don't qualify that signature, you give up all rights, titles, and interests to the property, and the property is the name. In that case, the court of law recognizes the rights of the assignee. So you have to take your own fault in that and recognize as the assignee, they were assigned. How were they assigned? By you, the assignor. So you have to step up and say, hey, wait a minute, I'm the assignor. I'm sorry, I made a mistake. But the subrogee has no standing whatever in a court of law. His rights are purely equitable. So he must admit his mistake and come with equity. I'm sorry, I made a mistake. That's the entrance into equity. I'm sorry, I made a mistake. I repent. Please forgive me. Here's my mistake. Express the trust and your position in it, how that estate works. And you recognize that the real party in interest is the estate, which carries your name. And you are the one that, in fact, assigned under SS5, the state, Social Security Administration, as the assignee, and therefore they are the trustee, and therefore they're the ones liable to pay the debts. Now that you understand this, you need to correct the law, or correct the records, and the first duty in law is give legal notice. The legal notice is mistake. That's your entrance into equity. And he should be compelled to file a bill in equity to secure their recognition. When the court permits him to sue at law, it is giving him a totally different kind of substantive right. Before the code, his rights were against the insured only. Under this view, he gets rights against the tortfeasor, the one that's actually committing the actions, the one that's actually doing the action. The police officer that pulls you across the road, he's the one that's actually physically doing it. The one that's insured is the executive that gave him that position as a local city police officer. And of course, we find out you don't actually sue them, you sue the surety company that's holding their bond. Again, it's a blanket bond that covers all the officials in those capacities. And now the tortfeasor, you get to sue them in their private capacity for that breach of trust, which is the tort. They tried to administrate your estate without your consent, and they did so forcefully through their actions. True, the practical difference between an action at law and a suit in equity in a case like this is very slight. Remember, the suit in equity is the filing of a suit in equity because of an action that somebody forced upon you. That's forced labor, the same thing. Remember 18 U.S.C. 1589, for what the law was not intended, and they're forcing commercial actions on the common man, which is common law. You cannot force contracts in common law. They have to be agreed upon, And the assignments have to be willingly, knowingly, and intentionally. A lot of things missing there, folks. Very slight under the codes. If it were filed as an equity action, the court would be enforcing a common law right anyway. But the equity court would be enforcing it in favor of one whom the court of law does not recognize. Sound familiar, John? You try to talk yourself in those courts and everything, and they don't hear you and they don't see you. They just do as they will. And greetings, Iman. My apologies. How are you this evening, sister?
All is well, bro. All is good.
Good
I
to
just
hear.
had a
Good to hear.
thought. I just had a thought though. You know, when you were talking about assignees and so forth,
Okay.
um, excuse me for this, but it's not me. I'm just reiterating what my cousin used to say. He used to say something about a jackass eating corn. And when you said that, I thought about the assignee, the ass, seeing all the signs. I yield.
Yep. They should. They're the ones that are being assigned as a trustee. I mean, technically, that's what you should be doing. So, no doubt, excuse me, my apologies. No doubt the code rule providing for one form of action at law and in equity had something to do with the conclusions the courts have reached. Okay, so like I've said again, the merger of equity with common law was the merger of trust law with contract law, and that's why it's so important to learn how to contract and learn how to construct trusts. Learn how they're created and everything, so you can see what they're doing before you. Every contract is in construction of a trust. Every application, every negotiable instrument is in construction of a contract, particularly when given out by people in offices, which are public trusts. That's a public service. You go down to the library and the librarian sits in her office. That's a public office. Go down to a local restaurant and the guy's sitting in his office. That's a place of public office. He's performing trade or business, the performance of the functions of public office. In its most basic sense, it's an office in public or an officer in public. Nearly all of them say the plaintiff gets his right by subrogation and then calmly hand it to him in an action at law. It is submitted that whether the action be at law or in equity, the insured is a necessary party. So, you have to enjoin the mayor if the local city police comes to you. He is the insured executive. You have to enjoin the county commissioner. He is the executive if the county sheriff or one of his underlings appointed under him, also taking oaths, comes at you wrong. Same thing with the state. Social Security Commissioner, Commissioner of Health and Human Services. Necessary parties are the ones that are bonded by the surety company already under public service. Bonds for the win. Introducing Bob. Bob is a public servant. Oops, what happened here? What happened here? Let's refresh and see if it gets. There we go. Introducing Bob. Bob is a public servant, and he must be. Damn it, doesn't give me enough time to read. Let's refresh again. and he must be bonded in order to take office. What is a surety bond? Surety bonds are financial guarantees, finance, settlement guarantees, right? Isn't that what we found? Finance means settlement. So surety bonds provide settlement guarantees that bondholders such as public officials, companies, contractors, or unions will uphold their contracts according to mutual terms. Equal consideration, equal benefit. You got a bond, I got a bond. Tell you what, who's your surety bond company? Here, I'm going to place my surety bond with him too. Okay? For the mayor, one for the county commissioner, and one for Health and Human Services. And then we're going to use expenses incidental to transfer that title to the agency, to transfer that title to Health and Human Services to get all the rest of those underlings as it relates to the estate, because it's Health and Human Services, regulated by federal regulations, required to have a estate recovery program administered by the Health and Human Services in every state. Surety bonds protect we the people from fraud and malpractice. We the people. We the people. Notice that's an entitlement. It's all uppercase. That's a title. We the people. From fraud and malpractice. When a bondholder breaks a bond's terms, the harmed party can make a claim on the bond to recover losses. So when I present my bond with their surety bond to their surety company and I make a claim, then the surety company puts all the value from the surety bond of the insured, the executive, for that claim into my bond, and then we get to transfer that to my account in credit form, special deposit. And they're the transfer agent that has to do it. They're already assigned to do these things. There are three parties included in a bond agreement. Bondholder, all elected public officials are required to be bonded, and they must sign an oath to uphold the Constitution of their state as well as the Constitution of the United States for America. Companies, contractors, and even unions are also required to have a surety bond. So they're telling you these are surety bonds. Okay? We the people, the community for whom the bondholder is obligated to serve. We the people. Surety bond company. This is the company that guarantees that the bondholder will serve the people. If a claim is filed against a bondholder, the surety bond company is responsible for accepting the claims. So you have to file it on the bondholder, but you file it with the surety bond or with the surety company, notifying the bondholder, demanding that the bondholder address the claim and starting an investigation if the bondholder does not resolve or rectify the situation. That sounds familiar with that. If there's an out of balance account with the general ledger, then the Postal Service is responsible to research and resolve it within 3 days. Sounds to me like the Postal Service is already the surety bond holder. The performance bond is the most common surety bond. This bond assures that the bondholder will properly execute all the terms and conditions of an awarded contract or to fulfill his or her duties to the public as specified. Company who issues and guarantees a bond is the surety. So when they're claiming you're the surety in these court cases, which is in fact what they're doing by action, they're claiming you issued the bond and guaranteed it. How is that so? If you don't have the corporate capacity to issue the bond, and we find out that you didn't in fact issue the bond, but they converted it and issued it for you. As the assignee, of course, with some kind of interest in it. See what they're running with, folks? I'm not going to let them play any more games with me, folks. How about you?
Yeah, there's no underwriter, right, Keith, for those bonds?
Yeah, we're the ones creating the bonds by the signature as an assignee already, assigning them without recognizing it, and by not qualifying that signature, and therefore we give up rights, titles, and interest to the property, and the property happens to be the name. Now they get to play with the name.
That's
That's the
securities
estate.
fraud.
Exactly. They're not qualified. As an officer alongside the road, they're not actually qualified to be a broker in securities. But that's what it ends up being. It starts out as a private investment. And then they pool all those private investments and broker them in their name as a security, a government obligation. So let's take a look at it again. It says, in a case where the loss exceeds the total insurance paid, the courts are almost unanimous in holding that the insured is the real party in interest. Some say the insurer may join, while others deny this. And the same rule is applied where the loss is insured with several insurers, no one of whom pays the entire loss, but all together do so. But where the loss exceeds the insurance paid, but the insured releases to the defendant, it has been held that the insurer is the real party in interest. Again, I want to remind everybody, you can't just name a defendant. The defendant must voluntarily appear in court after having received a summons and a waiver of personal jurisdiction. These are contract terms. It is submitted that in all these cases, the insured is the one and only real party in interest in action at law because the substantive law gives him alone a right of action. So having to pay insurance is proof of your right as real party in interest, as the only real party in interest in an action at law. So what are they doing? See, they're bringing an action in contract as an investment in creating money. Remember, investment is a creation of money. And they're doing so in the name of the court registry investment system after converting your last name to a firm name and stating that you are the holder of the obligor number, which is a Social Security number without dashes. That obligor number is a military style number under the selective service, because when you go to the Social Security site to find your selective service number, they specifically tell you to enter in your Social Security number without dashes. So it's somehow connected to the selective service or military side of the record. In my opinion, of course. That's just from my research. In some few cases, the right of the insured to sue has been put on the ground that he is the trustee of an express trust. It being provided in all the real party and interest statutes that such rule does not bar the trustee of an express trust from suing. It has, however, been denied that the insured is the trustee of an express trust on the ground that it is a trust imposed by law and therefore not express. This is why it's important to use the trust law to express the trust within the contract and let them know that. And it's not my contract, it's yours. You're the executive with the obligation under surety bond for we the people to perform for we the people, and that surety bond shows that you're the trustee required to do so, and the surety bond company is the obligated party to pay for any claims, and they will hold you because they are the regulatory party. They will make sure they don't care if you're the mayor or not. They'll find a way to get rid of you from that local community to quit letting these bonds come against them and put them out of business. It has, however, been denied that the insured is the trustee of an express trust on the ground that it is a trust imposed by law. Contracts for the benefit of a third party. When we come to the case of contracts for the benefit of a third party, the theories herein suggested are perhaps as nearly followed as in the case of any application of the real party and interest rule. In most cases, the courts discuss purely the principles of substantive law and assume without discussion that the real party and interest statute does not affect the situation. Such indeed has been the conclusion of every eminent authority. Eminent domain. That's what they're claiming, eminent domain, in respects to the safety and community concern and care of the people. That is their eminent domain. They are supposed to look out for the benefit of all of the people in the community, not just certain ones, and let certain ones be violated. That's why I said, when you think that your corporate actions are superior to that of the people who provide the very monies for those corporate activities, it's an egregious act against the very humanity that supports you. It is particularly not worthy that the leading case holding a payment beneficiary can sue, Lawrence v. Fox, which is regarded as having fixed the majority view of the law in America, was decided in a code state with a real party and interest statute several years before that statute had been enacted. So it's giving you a timeline. It is particularly not worthy, I'm sure that's supposed to be noteworthy, that the leading case holding a payment beneficiary can sue, Lawrence v. Fox, which is regarded as having fixed the majority view of the law in America, was decided in a code state with a real party and interest statute several years after that statute had been enacted. So it's showing that even the substantive law, even after the statute was put in place, still remained. And this is equity. In equity, the beneficiary is deemed to be the true owner. Anybody making an affront against the state, the beneficiary can make a claim against that party in the name of the estate, even as beneficiary. The beneficiary can come forth and make a settlement of the matters. The beneficiary can receive the property despite the fact that there's a trustee. The trust shall not fail for want of trustee. In that, if there is a trustee and that trustee is committing is acting as a tortfeasor and not appropriating things according to the assignment of trust law and subverting things through a presumed contract in legal fiction, then he would be a tortfeasor and he can be dismissed for executor days on tort for making false decisions. And we'll go over the irrevocable trust and the fact that it's an irrevocable trust, but that doesn't mean that it can't be changed, despite the fact that's how it's designed. The literal exemption is that a beneficiary can change it. Beneficiary can change it by his consent. That's the only way an irrevocable trust can be changed, is by consent of the beneficiary or all beneficiaries. In fact, the courts of several codes, some few, however, have persisted in the old error of deciding substantive law by a procedural statute. You can't do that. This is against the logic. Remember, we talked about logic in Socratic Logic series. You have to have a predecessor with a predicate. So the predecessor here is the substantive law. The predecessor would be procedural statute, which is bound itself by substantive law. It's the substantive law which is the choice of the plaintiff. And it's by that procedure that it goes. So the procedural statute is merely a attempt, in my opinion here, to take over probated estates that are created without somebody knowing. That's that burial trust as an irrevocable trust that can't be changed until the death certificate meets up with the birth certificate and can finalize the trust. That's what makes it irrevocable. But as a beneficiary, I can come forth and change it and make it a revocable trust and put property in it as my assets and collect up and create an investment fund so I can put forth my own private issue bonds as my own surety company. And I guarantee you, it's just like banking. You know what you're doing. You can create your own private bank. You can create your own private surety bond company. You can provide surety bonds for other people. All it is that you're willing to pay the claim. If you know how to pay the claim, there's no problem in it. It's all credits. And have said the third party could sue because he is the real party in interest. See, under that contract, I am the third party. But I'm not an officious intermeddler or an intervener. I am the real party in interest because you just made a claim against my estate. Now I get to sue in the name of the state as a cross-claim. Rather than sue in the name of the state as a cross-claim, I like to be preventive, so I want to think that I should be able to provide my own bond to the very surety company of any of these officials that would make that claim, letting them know, here's an equal consideration under full faith and credit of the United States, done in good faith with patent rights as the real party in interest, so that if anybody makes a false claim under which relief can't be had, because I didn't assign them as assignee, as in my capacity as a signer, as a trustee, then they have no business with it. Let alone the fact that if there is evidence of that, that would still mean that they're the assignee, the trustee. And by acting against the estate, executor days on tort. It should be remembered also that in most jurisdictions, the real party in interest statute, after providing that the real party in interest may sue, adds that a trustee of an express trust may sue without joining with him the person for whose benefit the action is prosecuted. See, if the public servant is operating a public trust, just naming a public servant is an expression of a trust. All you have to do is clarify that and let them know that it will not be prosecuted without joining you, so that you can benefit. Because you're not going to voluntarily waive personal jurisdiction. You will hold them to their trust capacity and not contract with them and remain the benefactor to settle these matters as the one that finances them. See how that language works? See, if finance means settle, then I come forth to finance this. This means I'm bringing my bond. That has the full faith and credit of the United States on it, and I am the real party in interest because it's got the estate name on it, and that happens to be very similar to my name. That's what I've been signing all my life. Have you been signing that? No. So that means you must have been an assignee, and I could only be the assignor. I'm the only one that can give you consent to sign in that name, to sue in that name. If the state gave it to you, that would be a false giving. If I gave it to you, it would be a false giving because I had no knowing, willingness, or intent to do so. That's the correction of the record. I made a bunch of errors, accidents, mistakes, whatever you want to call them. We're going to put a stop to them. That's my repentance. I'm not going to do it anymore. You can't make me give a blank endorsement. That's violating my rights as holder in due course to enforce an instrument by allowing me to put on my without recourse, without prejudice, pay to the order of da 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 da. If you can't let me qualify that signature as holder in due course, then you're the one violating securities laws. See what I'm saying, folks? And make a person with whom or in whose name a contract is made for the benefit of another. See, that's what they're doing. A person with whom or in whose name a contract is made. It's a constructive contrast in a constructive trust. For the benefit of another, a trustee of an express trust in the meaning of this section. So everybody's just operating as if though they're a trustee. Actions are similar to that of a trustee, known as an assignee who took on that obligation. But being the one that took on that obligation, as assignee even, under the statute, you still have a right to sue in the name. But what you're doing is you're clarifying that you're not contracting. You're using contract form to create the remedy, because that's what caused the controversy, the dispute, was the contract. Look at the contract. I didn't know this and I didn't know that. Had I known this, I wouldn't have done this. Or had I known this, I'd have done it intentionally. Knowingly, willingly, and intentionally. Basic of contract law. If you don't know, then you can't contract. If you're not willing, you can't contract. If it's not intentional, then it may be a mistake or an accident or an error. This evidently implies that a third-party beneficiary might have some rights, but it can hardly be said to give him any. A third-party beneficiary, again, equity says that the beneficiary is deemed to be the true owner. So he has two true owner rights already. Nobody's giving me any rights. I already have them as true owner. Always have and always will. Apparently, all it means is that if by the substantive law the third-party beneficiary is a real party in interest, this is an exception to the usual rule that such party must always sue. It's an exception to the usual rule that such party must always sue. So again, I don't have the capacity to sue, but as real party in interest, I can correct the record. I can make an investment with the United States under full faith and credit, under stamps and other representatives of value by transferring a bond, an obligation, or other security of the United States, along with a surety value and another surety bond for the mistake. Reference should be made to the fact that in the Code of Substantive Law of some states, it is provided that a contract made expressly for the benefit of a third party may be enforced by him. In such jurisdictions, of course, any question of the effect of the real party in interest statute on such case would be beside the point. In such jurisdictions, of course, any question of the effect of the real party in interest statute on such a case would be beside the point. In other words, it's saying that it's going to stick to the substantive law again. Reference should be made to the fact that in the Code of Substantive Law of some states, it is provided that a contract made expressly for the benefit of a third party may be enforced by him. So as long as you understand that those things that they're giving you are contracts and you are a third party to it because they are already bound by a contract and they're offering you a participation, you can participate as a third party beneficiary. That's all it is. Substantive law, the third party beneficiary is a real party in interest. Miscellaneous cases. The application of the real party in interest clause has been made to a wide variety of cases in addition to those already discussed. but they have not drawn the attention of judicial opinion to anything like the extent that the classes of cases already referred to have done. In the main, they are in accord with the theories of the real party and interest statute, which we have sought to set forth, though the conclusions have not been entirely uniform, whereas substantive law is. Okay? The following examples will suffice. Where grants real estate to B, where A grants real estate to B, X being in adverse possession in a jurisdiction where B's title is void as to X, A is the proper person to sue in ejectment. Okay? Whereas A grants real estate to B, X being in adverse possession in a jurisdiction where B's title is void as to X, A is the proper person to sue in ejectment. So let me ask you, is it the county that has the title or the bank? See, the county's the one that's got the warranty deed. Okay? And that warranty deed is the thing that grants real estate to B, the tenant, who professes to be the owner, but he's listed as tenant. Now, if that guy takes off and abandons that property and somebody else comes in and has adverse possession in it, he can't very well sue against B. If he's gone and can't find him. So again, just like you don't sue the mayor, you sue the surety bond company for the name of the mayor, and you name him. So you go to the county and you sue the county for the name of the guy on the warranty deed that they're guaranteeing. They're the ones holding the bond, guys. And where A, and again, this is not legal advice, this is just my opinion, and this is the way I would do it if I come across this situation, which is what I'm going forth with, is recovery of the estate and putting that title in the proper hands and correcting all the records along the way, making all parties whole, settling all debts and clearing all creditors. Where A has land to which a water right is appurtenant and grants it to B in order that B may litigate to determine the extent of the water right, B, having agreed thereafter to recovery to A, B is the real party in interest to sue adverse claimants to the water right. So if an adverse claimant comes in because B is gone, he has to make a claim against A. And he has to make a claim against A even if B is there, because he's making an adverse possession claim against the grantor. The trustee is the holder. And unless he's misfeasance or malfeasance of trust, he's not the right party. He's holding the property. The grantor, the one grant to A, he's the one that has that surety bond, that entitlement, granted the entitlement. But when it comes to B for them water rights, he's got to sue the adverse possessor. Same with the land rights. If B's there and an adverse possessor comes in and tries to take over, that adverse possessor has to have that land in adverse possession for a number of years. So if B comes back, it can't be considered abandoned, usually 7 years. Just like if you were lost at sea. It would be presumed that he was lost at sea. He went out about the land or got lost somewhere and is now a decedent and hasn't come back and maintained the property. So now the one in adverse possession is gaining real interest in the property by maintaining it. But he's never been an assignee. So if he wants adverse possession, he's got to go against the assignor. Problem with all of this, again, you can't go against those if they're not in the right name, right, guys? Are they estates or not? A remainder man is not the real party in interest to recover possession of land from third parties during the continuance of the life estate. A remainder man is not the real party in interest to recover possession of land from third parties during the continuance of the life estate. See, the remainder man is that fiction. Remember I talked about a remainder? After you settle all accounts and clear all creditors, there's going to be a remainder. It's known as the insurance credits that are sitting there, the unearned income credits, fines, fees, and penalties that were paid when they weren't just, and therefore aren't due, and therefore all those contracts are voidable and thus void. It is held that real property and interest statute does not permit an undisclosed principal to sue on a contract under seal made by his agent. It is held that the real party and interest statute does not permit an undisclosed principal to sue on a contract under seal made by his agent. So again, we can't contract or can't sue on the contract. You're not going to sue on the contract. You're going to take the contract for being inconsistent, try to fill in the gaps that are inconsistent. When you find out they can't be filled in, it becomes an impossible contract and therefore voidable and therefore void. And anything put into it as equal consideration that others benefited from, you get back in return as your benefit. In conclusion, it may be said that a review of the decisions convinces one that the mass of litigation on the real party and interest statute is but another illustration of the sort of much ado about nothing, which is all too frequent in legal discussion. In other words, what they're saying again, that party and interest statute isn't needed. It's a statute. It's already there by the choice of substantive law, and the only reasons it's there is to show you differences. It's an educational statement showing you a distinct difference, a different jurisdiction, at law versus equity. So if it's at law versus equity, what is equity? Is equity in law? See, at law is the contracts. They're not law. They're at law. They're at the edge of law, and they're supposedly presuming that they follow the law, but they don't once you find out, because they don't follow equity. They're equitable. Like I said, you can go back and fix the inconsistencies, and if you can fix them all, that is equity. You've made them whole. Now everybody can participate and fulfill their obligations and receive their equal benefits and equal considerations. But if that's not so, then something's out of balance. Instead of going to the heart of the matter and deciding why the substantive law gives a litigant a right, courts have dodged behind this statute and said, oh, well, anyway, he is a real party in interest, so of course he can sue. In most cases, it might be said with equal penetration that he is the one to sue because he is rightfully the plaintiff. See, they're not supposed to be naming you defendant at all, folks. If you're not a public officer, you can't be made a claim against for breach of contract under that trust. You don't have an oath of office, and you don't have a license that is valid. There are elements missing. Everybody needs to go back and reflect on that, find out what those elements that are missing are, such as resident determination, and the fact that United States citizenship is a business known as the United States business. And if you're granted a business, what is that business? All the statute proposes to do is to eliminate a few instances where one man sued in the name of another, and to reiterate a rule of law as ancient as it is axiomatic, that the man with the substantive right is the man who can sue. And while a few jurisdictions still make use of this statute as a means of muddling questions of substantive law, the majority are coming more and more to the view that it is purely procedural. And it's all a matter of administrating a probate estate. That's the procedure. That's the procedure that we have to rebut. Sorry, that person was created for my benefit as a conference of a nationality, a gift, a grant itself. That means that the United States is the one that's the grantee. And the Secretary of State is the one that gave me this bond as an obligation or other security of the United States, telling me that they were the holder of the bond. And when I requested it so I could settle something, in other words, finance things, I want to settle all the accounts so that all the remainder credits are converted and resurrected and merged into a new name. That's all I'm doing. That name is defamed, and he's no respecter of persons. So under your contractual form, we'll provide the contract form, but understood that the contract is already there, you're the contractor, and you're being held to your obligations now. That's all we're doing. And with that, we come to the end of the stream for tonight. You got anything for us, Iman?
Yeah, I just typed a question in there for you, just for you to confirm for me, brother.
No oath of licensed office by an officer. No, they all have to take an oath.
Yeah, that's what I meant. That's what I was putting in there. I don't know why I put the no in front of it, because they have to be licensed under oath, and being licensed under oath, they would have to uphold the Constitution, which is a contract, and it's based on rules and regulations and policies that are ordinance through a legislative body, correct?
Correct. And that legislative body is merely passing on the letter of the law as so supposedly put down by Congress, who shall lay and collect taxes, duties, and imposts and excises, and make rules for the government. So what's all these statutes? I mean, those are federal acquisitions under contract terms and conditions. All of them. So with that, you got anything else to say at the end?
No, I thank you, brother. Like I said, it's all praises to the Most High Creator, and that bring us together to be able to, you know, reconstruct this situation so we all can be free in the end. That's all. That's all.
Absolutely, absolutely. Like we looked at last night, liberty. That's what we're looking for, is a liberty, and the only way you can have liberty, again, is knowing your plenipotentiary powers and how to assert them as holder in due course and enforce things. You are the enforcer, not them. So with that, you guys know me. I love you, but I don't give a rat's ass whether you love me back. And I have to say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. Bye now.